Judge, if I can approach.
All right. Okay.
Judge, we're here today for a competency hearing. Shared the report with the prosecution, stipulate to its admissibility, and the court considering it for today's purposes.
Oh, yeah, this is Mr. Hawkins. Okay, yeah. We'll set him, the court adopts the Dr. McDonald's evaluation, and if I recall, it's a six to 12 months to restore competency.
That's correct, Judge.
And then we'll just set him on a docket. We'll bring him back. Do we need to do that, or just wait for a report from the?
What we've been doing is setting it for a review every 6 months, just to see if
Set it for a pretrial conference day in 6 months. Or finds he's incompetent to proceed.
Is the court ordering a particular placement based on the evaluation?
Florida State Hospital.
Yes, Your Honor, the state would agree to that.
All right.
That would
August 26th be good. All right, we're going to see if we can get you some medical treatment, Mr. Hawkins, and bring you back in August, see where we're at, okay?
Yes, sir.
Thank you, sir. I think I need to give you that report back.
Oh, that's all right. I have,
All right.
in fact, 2 other copies.
Okay.
Did you file it, Mr. Williams?
I gave it to Sarah, and she knows what it is.
Oh, okay, no, just to know if I had it in my records or not, that's all. Oh.
Well, I've got an extra copy for you.
Thank you, you don't have to. Thank you.
All right, this is Malik Jackson, correct?
Yes, sir. Judge, Mr. Jackson has 2 cases. He's got a new law violation that I think is on for this afternoon. Yes.
Yeah.
We're going to enter a denial on the VOP, enter a plea of not guilty on the new law violation, request 15 days for any pre-arraignment motions, and demand trial by jury.
All right, that was his arraignment on possession of a weapon or ammo by a convicted felon for this afternoon, correct?
That's correct.
24 CF 282, so he's not pleading not guilty on that, correct?
That's correct, Judge.
We'll set him for when? June 24th or something like that?
I think pretrial April 22nd, Your Honor.
22nd? Okay.
And both cases can track together.
All right, we'll run them together. Thank you, sir.
Thank you, Judge.
How are you? Judge, for the record, that's 24 CF 84 and 24 CF 85. For the purpose of today, we're hearing a motion to modify his bond that we filed a notice for today. Essentially, what we're asking the court to do is to reduce his bond. He has a bail value in the aggregate of $126,000. We're asking the court to substantially reduce that. He is a juvenile, so it'd be on his family to post that. He is a resident of Texas, so we acknowledge that. But we're at basically the $126,000 is tantamount to no bond at all. So if the court wanted to impose a GPS monitor or something like that to assure his appearances or anything like that, we'd be willing to comply.
State.
The state objects, Your Honor. The state believes that the bond is appropriate in this case. The evidence that is already in possession of the state is a lot. There are concerns that there may be other charges coming against him out of other states because apparently there is information that he committed the same violent crimes in other states. in other states. It's the state's belief that because this defendant is a resident of Texas, and we have information that at the time he committed those crimes, he was on probation in Texas for battery on a law enforcement officer. We have information that his family situation lacks stability. Also that his mother has pending felony warrants, so there is no guarantee that this defendant will come back for trial. Additionally, the main concern of the state is the security and safety of the community. The crimes for which he's been charged caused panic at Baker High School. He made threats of a bombing, and he's been doing this, and this is not the only time he's done that. In addition to that, he called law enforcement against another victim as a swatting type of crime, claiming that there was going to be a murder or some violence happening at the house of this victim. The victim happens to be a gang members. Apparently, and the relationship, Your Honor, is with the other defendant, this court heard the other juvenile, Whittington, who's been prosecuted by Ms. Glisson. The state believes that if he were really...
The court feels he's a flight risk and a danger to the community. The bond will leave the bond the way it is.
Thank you.
Thank you, sir.
Judge, that's all I have on the docket today. May the court entertain Ms. Boston approaching a case we had set for trial on Monday, off the record real quick?
Yeah.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Dave's Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at davestilepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Mr. Daniel Arn is present and approaching, and 23 CF 2610 is a VOP, and we've entered into a global resolution addressing his two other pending cases, 24 CF 418 and 24 CF 451. He's going to be pleading to misdemeanors and time served on those, and the underlying DOP is also a misdemeanor as well, so there's no score sheet. If I may approach with the plea.
Mr. Arn, would you please raise your right hand to be sworn? You swear the testimony you give for this court is true, so help you God.
Sir, Your Honor.
Thank you. This is State of Florida versus Daniel Arn, 23 CF 2610 VOP and 24 CF 418. And also 24 CF 41451. And in 24 CF 418, the state's going to drop count 1 upon a plea. And then he'll plead to a misdemeanor simple battery in that case. And in 24 CF 451, state's going to drop count 1, and then he'll plead to a simple battery on that case, correct?
Yes, Your Honor, that's.
And then admit that he violated probation in 23 CF 2610, correct? That's what you want to do, Mr. Arn?
There you go.
Did you read and sign this plea and sentencing agreement form? Where the rights you're waiving by entering this admission and this plea? Has anyone forced you or threatened you to enter this admission and plea? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Ms. Flowers has done for you on your case? Court finds the admission and plea is freely and voluntarily entered. Court accepts it. On 23 CF 2610, judge guilty, reinstate probation and complete the original terms and conditions, credit for time served, $100 VOP fee, $100 cost of defense. In 24 CF 418, count 2, which is a misdemeanor, you're judge guilty, credit for time served, $270 court cost, $150 cost of defense, all monies to collections. In 24 CF 451, count 2, a misdemeanor battery, you're judge guilty, credit for time served, $270 court cost, $150 cost of defense, waive cost of supervision, and I think that's it. Adjudicated guilty on all cases, all counts that he pled to.
Thank you. That's it.
Okay, thank you, sir.
Ms. Davis? Your Honor, this is Chana Davis. She was put on today's docket just to show that after having a KPS recall due to a hospital visit, we're asking just to put her back on the pretrial docket.
April 22nd. Okay, thank you.
Thank you, Judge. I believe that's all I have today. Thank you.
Oh, and we are going to pick the jury on it March 18th, and the trial will be March 19th.
Yes, Your Honor.
Yes, Your Honor.
Okay, thank you.
Okay. I think we're still doing your inmates, Mr. Williams.
Next,
So I thought we'd work till you started talking. Judge, this is Brandon Kelly. He likewise has a case that's set for arraignment on March 28th. So what I'll do is I'll enter a denial for him on these cases, ask them to track with the case that's scheduled for March 28th. If we can get it resolved by then, we will.
is this Travis Kelly?
Brandon Kelly, Judge.
Brandon Kelly?
Yes, sir.
Oh, Brandon Lee Kelly. Brandon Lee Kelly, okay. So, all right, your attorneys pledged you not guilty, asked for a trial, or denied your violation of probation. So what you want to do, April 22nd?
No, Judge, these are VOP cases. He's got a new law coming in for arraignment on March 28th. I
you
don't
wanna
believe
do
the
it on
state's
March-
filed an information on it as
I
yet.
think I have.
You think you have?
Yes, I'm not sure if it's reflecting on the court record. I don't know. I did it. I prepared it.
No, we don't have one. You don't have an offer for him to cover everything
Yeah, I do.
for today?
Yep. 48 months DOC, revoke and terminate.
Judge, I don't think we're going to be prepared to take that without me at least looking into the new law violation. So I've got motion for bond I'm going to file for him, and we'll get him in on the 28th for that.
And, if I may
It
ask,
was 48 months.
48
How much
months,
time has he got already?
I'm not sure, in the prior case, what he had.
Yeah, in the prior case, he's got a fair amount, I imagine, but on the new case, he's not going to have more than a month.
Okay, what day did you want?
Judge, just go ahead and leave him on for 3/28
Okay.
for arraignment.
March 28th. Thank you, sir.
Thank you,
And,
Judge.
Your Honor, please, can you remind the defendant that there is a no contact order there, that it applies also while he's incarcerated? I have information that he's been contacting the victim in the case.
Well, if you haven't, oh, no, okay, well, don't. If you, just make sure you don't.
I haven't called nobody except for my girlfriend, so she's grown, so I haven't called nobody.
All right, thank you.
Pull all records, all of them.
Okay, thank you.
Ms. Medina.
Judge, this is Stephanie Medina. She's here for a bond hearing.
What's her bond? Already? Oh,
Judge, she's got a couple of VOPs, and the court issued a no bond.
Judge, she was on probation for a case, and she was also on, she had a misdemeanor case also pending that she failed to appear for. She's absconded from January 8th of 2023 to December of 2023. So she was absconded from
I
us.
don't like absconsion, so no bond. Thank you.
Yes, sir. Yes. On Ms. Medina, I need another, she was originally set for 3/28 for her VOP date. No, I'm looking at Brandon Kelly's. On her, no, she was set for today, so we will need another date.
March 28th. All right, this is Mr. Newell.
That's correct. Judge, we have a negotiated plea in the case.
All right. Do you have any hearings this afternoon other than a plea?
I don't.
Okay.
Yeah. Get your signature on it. Hang on, let's make sure I'm looking at the right file. Yep, okay. See your county vehicle credit. Sure.
Mr. Williams, on another matter, on that trial, Kurt DeLyons,
Yes, sir.
we had him going on the we're going to pick a jury on the 11th instead
Yes,
of
sir.
the 14th.
You announced that earlier, and I've already emailed my legal assistant.
Okay.
Asked her to get in contact with him and let him know he's going to need to be there on the 11th. She's also scheduling an appointment for him with me tomorrow to go over the revised offer.
All right, and so that is the only jury I'll be selecting Monday.
Oh, okay.
Is that correct?
Yes, it's correct,
Okay.
Judge.
All right, you get me the instructions and all that by
By tomorrow at noon,
tomorrow,
yes, sir.
yeah,
Yes,
okay.
Judge.
Okay,
Yes. All right, Judge, so with that, Mr. Newell's going to admit the violation of probation. in exchange for a sentence of adjudication of guilt, 1-year county jail with credit for time served.
All right, Mr.
Send the monies to collections and revoke and term.
Mr. Newell, would you please raise your right hand and be sworn? You swear the testimony you give for this court is true, so help you God. Okay. This is 22 CF 716. Mr. Newell, you want to admit that you violated probation?
Yes, Your Honor.
Are you aware of the rights you're waiving by entering this admission?
Yes, Your Honor.
Anyone force you or threaten you to enter this admission? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Mr. Williams done for you on your case? Court finds the plea, the admission is freely and voluntarily entered. Court accepts it, revokes and terminate probation, sentence you to, is it 1129, you said?
Yes, sir.
11 months, 29 days, Okaloosa County Jail, credit for time served. Standard court costs, cost of defense, what else?
Well, there won't be additional court costs on a VOP, so
All
it'll
right.
be the outstanding sent to collections, Judge.
All right, any outstanding to collections?
Just for clarification, counts 1 and 2 will be 1129 a day. Those can run concurrent. Count 3 is a second-degree misdemeanor, so.
All right, all concurrent. The second-degree misdemeanor, 60 days concurrent county jail.
Thank you, Judge.
How much time have you got in there?
Going on 9 months right now.
9 months? Well, you'll be out in probably another 2 or 3 weeks, maybe.
Thank you, sir.
Probably, you might miss some
just
Easter,
July 1st.
you might miss some Easter egg hunts, but after that, you'll
Thank
make,
you, Your
you'll
Honor.
make, Labor Day, is it, May?
Yes, Judge, it's in May.
Okay.
All right, thank you.
One more, okay.
And then I've got to call Mr. Lee's case. I still have to call it up.
This is Mr. Lee
No, Judge, this is Mr. Hastings.
Hastings.
Let me find the copy that. Sorry, Judge, I got Mr. Hastings' signature last night, and I'm looking for the, oh, I think I already gave it to the state.
This is Wesley Hastings, right?
That's correct, Your
All right, Mr. Hastings, would you please raise your right hand and be sworn? You swear the testimony you give for this court is true, so help you God?
I do.
All right, let's see. You want to enter a no contest plea to the lesser included offense of lewd and lascivious molestation, defendant over 18, victim under 12, Florida statute 800.04, paren 5, paren B. You want to enter a no contest plea to that charge, a lesser included offense of sexual battery, capital felony. This is...
No, Judge, he's charged with the capital felony. He's pleading to an L, a life felony with a mandatory minimum 25 years. He'll be sentenced to 25 years. It's a 800.04 offense, so there will be no gain time.
And the state will be filing a nunc-pro-tunc information. It's technically not a lesser included, but it will be the 800.
Oh, it says here LIO. What does that mean?
Lesser included offense, Judge.
It's
Why-
not
that's why
technically an
I read it.
LIO.
That's why I read it, lesser included offense, because it says here lesser included offense, but it's not going to be. So he's going to be pleading to not a lesser included offense, just the offense of L&L molestation, defendant over 18, victim under 12, correct?
Correct.
All right, with a maximum incarceration of life and a minimum mandatory 25 years, gain time not available on that offense, correct?
Correct.
So you understand all that? You understand that, sir?
Yes, Your Honor.
Okay. Did you read and sign this plea and sentencing agreement form?
Yes, I did, Your Honor.
Are you aware of the rights you're waiving by entering this plea?
Yes, Your Honor.
Anyone force you or threaten you to enter this plea?
No, Your Honor.
You fully discussed this plea agreement and possible charges or the possible sentence with your attorney.
Yes, Your Honor.
You happy with the work Mr. Williams done for you on your case?
I'm sorry.
You
what's
happy
that?
with the work your attorney's done for you on your case?
Yes, Your Honor.
Is there any DNA evidence that would help out Mr. Hastings that have not been provided to him and his attorney?
Not that I'm aware of, Your Honor.
Stipulated and factual basis?
We do, Judge.
Court finds the plea is freely and voluntarily entered. Court accepts it. Judge guilty, sentenced to 25 years mandatory minimum. Department of Corrections, followed by sex offender probation for life with GPS monitor, designated as sexual predator with reporting requirements, including report every 3 months. Standard terms and conditions on probation, plus the following special conditions: no contact with minors, no contact with victim or her mother. And of course, adjudicated guilty. Anything further?
Yes, Your Honor, if I may, the victim's mother is present today, and she does have a letter that she does not wish to read, but she wishes to be part of the court file, if I may
Okay,
approach.
that's,
I have reviewed it. and
That's
there's no
good.
objection.
all right, and does she request this to be filed in the court?
Yes, Judge, and my secretary will do a confidential filing for the letter.
All right. It's, the court will do that. The court read it, and, of course, the sentence is minimum mandatory 25 years in prison. So,
Yes, Judge.
Yes, sir.
all right. Anything further?
No, Your Honor.
Nothing further from the defense.
Thank you, sir.
Honor, final supervision, the supervision fees waived and GPS $1 a day.
Yes.
Judge, we have another case, William Lee. Mr. Lee is incarcerated. He was returned to the county jail. He had a medical episode, and I consented, based on the medical episode, for him to be returned. Judge, we've gone back and forth with, the state has made an offer. We've made a couple of counter offers that have been rejected. Judge, we can set this, I think maybe even bring him in as early as 3/28. I'll go out to the jail and advise him that the state's rejected his last counteroffer. If it's a situation where he's
All right,
not-
March 28th.
Thank you, Judge.
All right, is that it for now?
That's it for now, Judge.
Just my inmates, Judge.
Pardon? Yo, you got some.
Yes. But I'll try to be as quick as possible, Judge.
That's all right, I understand. I just thought you were finished. After I issued that capias, I saw you vanish. I thought,
I had to run away a couple times, Judge.
He thought he was next.
Had to go prepare for getting arrested. Your Honor, first I have Mr. Nicholas Adkins. This is 23 CF 373, 23 CF 531. Judge, Mr. Adkins is going to be going on conditional release. We have the plans here for him to sign. I'll send the court an order to find him not competent. We had a report by Dr. Zeman. I believe the state stipulating to admitting not report.
The state stipulates.
all right, court adopts it too. I
So
remember
we just
that.
need him to sign his conditional release plan, and I'll get that submitted, Judge.
All right.
Just need you to sign right here, okay?
Yes, sir.
And then I'll give you this copy.
Sorry.
It's okay. Just sign right there for me, please.
What's the date, Mr. Chairman?
March 7th.
I just was trying to.
That's your copy?
Sorry, see what?
That's your copy.
That's
If I may
okay.
approach, Judge.
Sorry, Mr. Tippett, I was gonna apologize to
All right, so he is going to,
Right here for us, right now.
Mr. Atkins, you've read through this conditional release plan. You want to go ahead and complete it?
Yes, sir.
All right.
Oh, yes, sir. Mr.
Okay. You discussed it, you fully discussed it with your attorney, Mr. Gibbs?
Yes, sir, Mr. Judge John J. Gunter. Yes, sir.
Okay. So he has he met with Mr. Barnes and gone over this?
He
with
has, Your
him?
Honor. Mr. Barnes provided that plan to us this morning.
All right. Are there any questions about it?
No, sir, I understand. First, I guess, Mr. Judge. Yes,
All right.
Mr. Judge John J. Gunter.
Okay, thank you.
Yes, sir, Mr. Judge.
Thank you, Judge.
All right, is there anything else we need to do? Just
That's-
submit it?
I'll send you an order, Judge.
All right, thank you, sir.
Thank you.
Thank you. Yes, Mr. Judge.
We'll get you out later today.
All right, thank you.
Your Honor, Tim Gibbs on behalf of Ryan Belck. Judge, we're here for VOP arraignment on 22 CF 1477 and 22 CF 2278. Judge will enter denials on those. He also has 24 CF 454. I believe the state's filed in information on that one. That's set for arraignment later this month. I'd like to go ahead and arraign him now, enter a plea of not guilty, and request to set everything on April 22nd for pretrial.
All right, well, I don't know what his new charge is. Do you know what that is?
His new charge, Judge, allegations include during a traffic stop with Deputy Peak that altercation ensued and Mr. Belck allegedly had grabbed for Deputy Peak's taser during that altercation. So there's some resisting charges as well as depriving the officer of his taser.
All right, he's pled not guilty for that. Court appoints public defender. And same with the VOP. And run it, what, together?
Run them all together on April 22nd is what I would request, Judge.
No, Your Honor, I was going to ask to set for a VOP evidentiary March 28 at 2 p.m.
All right, March 28th at 2. Thank you.
Thank you.
Thank you, March 28th.
Judge, if I can be excused, 12:30 for pretrial detention hearing?
Yes, sir. I think we only have 3.
There were 4 following the document.
Well, one of them went away. Miss Dudley's case.
Your Honor, Tim Gibbs on behalf of Bobby Joe Booker. This is 23 CF 388. I believe we've reached an agreement, just need to sign the plea. That's what you want to do, just sign right there for me, please. And then today's date, please, March 7th. If I may approach, Judge.
Yes. Ms.
course, you-
Booker, would you please raise your right hand to be sworn? You swear the testimony you give before this court's the truth, so help you God. Swear to tell the truth? You want to admit that you violated probation? Did you read and sign this admission agreement, plea agreement? You aware of the rights you're waiving by entering this admission? Anyone force you or threaten you to enter this admission? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here? You happy with the work Mr. Gibbs has done for you? Court finds admission freely and voluntarily entered. Court accepts it. Will reinstate probation. The next 12 months are on community control. $100. Well, reinstate probation with community control sanctions. $100 cost of prosecution, $150 PD fee, complete original requirements, adjudication is withheld.
Thank you, Your Honor.
Okay?
Good luck. Just meet with
All right. Waive cost of supervision.
Thank you, Your Honor. Your Honor, Tim Gibbs on behalf of James Burgess. Judge, this is 23 CF 2488. We are here for a motion to reduce or modify bond. Judge, Mr. Burgess has been incarcerated currently since November 4th, 2023. He currently has an $80,000 cash professional bond. He's unable to make that bond. He's entitled to a reasonable bond, Judge. We're requesting a $10,000 total cash professional bond with pretrial supervision. He's lived in the area for 21 years. He would reside at Oxford House. He has a job lined up locally. He has 2 minor children that he cares for. He's has restaurant experience for 15 years. He's ServSafe certified, so there's no issues with him being able to find work, to find employment. And Judge, while he's been in the jail since November, there is actually the Emerald Coast Life Center has a pod in the jail for treatment. He's been in that pod. Ms. Dana Claw is the director of that. She's been working with him on treatment as well. We have been working with the state and trying to negotiate this out. I don't think we've quite reached a negotiation on that yet, an agreement on that. Additionally, regarding the facts of the case, this is there was an allegation that a vehicle had been reported stolen. Officers met Mr. Burgess and Mr. David Fiducia at the Goodwill here in Crestview. Mr. Fiducia, I believe, actually admitted that he had stolen that vehicle, that Mr. Burgess was the passenger, had nothing to do with the vehicle allegedly being stolen. Mr. Burgess ultimately ended up having, I believe, an overdose at that time. He was taken to the hospital, and then somehow the law enforcement caught up with him and searched him. We'll be looking into that as far as motions to suppress if there's anything there. But we're asking for a $10,000 total cash professional bond so he can bond out, Judge.
Was this a VOP or new charge?
No.
It's a new law, Judge.
It's a new law, Your Honor. In this whole argument, I guess we forgot to mention, he's charged with trafficking in amphetamines, first-degree felony. He's facing a 3 years minimum mandatory, and the minimum guidelines set him at 46.65 months. Now, I want the court to be aware that I had extended a very generous offer, given the evidence that I have and the charges that he's facing. For an 1129 in jail, Your Honor, continue in the pod for his substance abuse, and then get out on probation. He has rejected that offer, and at this time, is not on the table anymore.
If he's facing a minimum mandatory, I'm gonna leave the bond the way it is. Usually I set no bond on a minimum mandatory, so I'm gonna leave the bond the way it is. Thank you.
If the offer is revoked for what we were discussing, okay?
Looking to. All right. Thank you, Judge. I think he's already set for pretrial on the 22nd. If not, then we'll just ask for that. Thank you, Judge. Your Honor, Tim Gibbs on behalf of Brian Crocker, Judge. This is 24 CF 63, 23 CF 626, 23 CF 2360. Judge, we are close to finishing this out. He has an offer for either DOC or Keaton. We're waiting on the Keaton response, so we just want to set this for the 28th. That's our next court date, and we should have our answer by
That's fine,
then.
Your Honor.
Thank you, sir.
Yeah.
Thank you, Your Honor.
Thank you, Judge. Yeah, we'll get that response. Your Honor, Tim Gibbs on behalf of Gregory Guer, Judge. This is 22 CF 2274, 22 CF 2713. I believe we reached an agreement. We're just going to have him sign that, Judge.
Wake him up. You got me all shook up on this one.
Still what you want to do is sign right there for me, please. March 7th. 7. March 7th. If I may approach, Judge.
All right.
Score sheet included without objection.
This is Mr. Geiger.
Yes, Your Honor.
Mr. Geiger, would you please raise your right hand to be sworn? You swear the testimony you give for his court's the truth, so help you God?
Yes, sir.
Okay. You want to admit that you violated probation?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
You aware of the rights you're waiving by entering this admission?
No, I don't.
The rights, you have a right to go to a hearing. By entering this plea, we're not going to a hearing for the judge to determine if you're guilty of a violation. Reach this agreement. Do you still want to go forward with this agreement? Do you think it's in your best interest?
Yes, sir.
Has anyone forced you or threatened you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, sir. Yes, I am.
Court finds admission freely and voluntarily entered. Court accepts it. Sentence to 24 months, Department of Corrections, remains suspended. You're sentenced to 11 months, 29 days, Okaloosa County Jail, waiving credit only for this plea, followed by a new 11 months, 29-day probation to complete original requirements. Pose a total $100 VOP fee?
200, Judge, 100 for each case.
$200 VOP fee, $250 PD fee. Attend ECLC classes while incarcerated, adjudicated guilty.
Thank you, Your Honor. Yeah, essentially the idea is starting from today, he would do 11 months, 29 days, less any gain time to complete the ECLC treatment pod while in the jail. After he gets out, he'll be on 11 months, 29 days of probation, and the 24-month suspended sentence that was already imposed remains suspended, conditioned upon his successful completion of that new probation term.
So he still gets credit for some time served? Is that what you're saying?
Essentially, the agreement is that he's waiving prior credit only for this plea in order to do a fresh, what we consider a fresh 1129 sentence to complete the treatment in the jail with the ECLC pod.
State agree to that?
Yes, because the alternative would be to impose the suspended sentence, so.
Okay, I got you.
Yeah.
Oh, I see.
He still
Okay,
ends
yeah.
up spending less time incarcerated with this plea by
I
my
see.
estimate.
Now I see why you.
And he can have classes to help him out with his problem.
Okay. So he does spend less time with the jail. All right.
Have any questions about it?
All right, next.
Your Honor, supervision fees waived on that?
Yes, yes, sir.
Thank you, Judge. I think that completes all of my business this morning, Judge.
All right, very
I have
good.
one other on docket, Ms. Ellis, but we're going to bring her this afternoon. I saw that, I overlooked that she was not on.
I got you.
Thank you, Judge.
Okay. All right, so we have some 12:30 hearings.
Yes, Your Honor.
Okay. All right, thank you.